Dear participants, dear colleagues, dear friends, it is my pleasure to welcome you today as Director of the Transatlantic IP Academy to our third encounter on international IP and access to pandemic medicines. This encounter is really central to our life, and I'm happy that in this cycle of encounters, Fide and TIPSA pull their forces together in order to reach a very large audience. We are hundreds of colleagues and participants connected throughout the world, and we are really, really happy to discuss in this cycle of encounters on the future of the IP world in a post-crisis environment. The current encounter focuses on a topic which really matters for all of us, for our present, of course, but and above all for our future. How the international IP system will permit better research, better discoveries, better access to medicines, safer, better and more fair IP system. For this purpose, we have invited two of the best colleagues and experts in the world, Henning Grosse-Ruisekam from Cambridge University and Rochelle Dreyfus from New York University. This is therefore a major pleasure to have them on board. And I wouldn't wish to make an introductory speech which is too long. I would just wish to thank warmly our sponsors who have tremendously worked also for getting the largest possible audience. I would also wish to inform all participants that together with the Fide Foundation, we have decided that the cycle that we have launched will last for at least 1 year with encounters every month, since we are meeting success of audience and we have splendid speakers. Our next encounter will be on the 22nd of July, dedicated to a new world for IP arbitration. And then we will have further encounters as of early September and for the whole of the academic year 2020-2021. In organizing these events together with Fide, I would wish to warmly thank Fide for its role, the Fide Foundation, and in particular, Javier Fernandez Laschetti, to whom I give now the floor. Javier, the floor is yours.
Thank you, Laurent, and thank you all for coming, and thank you to Rochelle and Henning for accepting the invitation, being so kind to share their views and their knowledge. And thank you also for all the documents that you have recommended to us in order to continue studying this very important issue that is about the necessary balance between IP rights and rights of the human beings. Something that in our IP community are very accustomed to do, because the story or the history of IP is the history for balance between the rights of consumers, the rights of inventors, the rights of creators, etc., etc. So I'm sure that the IP community will be able to find a solution for this need of a balance solution for the treatments of the human beings. We are creating a community. If you go to our landing page, you will see not only the former encounters, but also lots of information, lots of useful information. But we kindly invite you to take a look to it and to contribute, if you wish, with interesting documents that will be useful for all the members of the community. As Laurent has said, we will continue with this activity that we are very pleased to hold together with TIPSA and with Laurent, and enjoy the meeting. Thank you, Laurent. The floor is yours again.
Thank you very much, Javier. This is really an honor to work jointly with Fide in this activity. I don't know if I should really present our two speakers. They are so knowledgeable and so much well known. It is really a very special moment for us, since we have both experts, both academics, who really pave the future of intellectual property, and in particular in the field of access to medicines. Rochelle Dreyfus is a professor at at New York University, and is the not only is she a lawyer, but she's also a chemist by training. So who else better than Rochelle can talk on the importance of intellectual property connected to science and to patents? As such, I would not quote the immense series of publications that Rochelle has done. I would not detail all the fields of activities she has worked, including in the US and all around the world, in order to promote the importance of patents in the field of intellectual property, and also critical views on them. I would just quote that she's the author of a book on patents and access to medicine that is published in English and also in Spanish, and that also focuses on access to medicines in Latin America connected to patents. So this is really at the heart of what we will discuss today. In addition, Rochelle really is nice enough to dedicate a lot of time to our activity and to its preparation, jointly with Henning, who has worked hard on a series of questions that we have agreed together. Henning Grosser-Rüsekan, after working at the universities of Münster and Leicester and at the Max Planck Institute for Intellectual Property in Munich, Germany, became co-director of the Intellectual Property and Information Center of Cambridge University, where he's senior lecturer, and as such specializes in international IP law, in IP and trade law, and examines the systemic issues connected to intellectual property in the global world. So at this very stage, I really would wish to thank them warmly for being with us, and wouldn't wish to take more time, and simply to raise a few questions that we had discussed together. So Rochelle and Henning, what can we learn from IP from the COVID-19 pandemic? And in this sense, this encounter examines the relationship between international IP obligations and access to vaccines and treatments. Before we look at specific issues, can you give us an overall picture?
So I think that question, I'll start answering that question and then Henning can continue. So thank you very much for inviting us to do this. I very much enjoyed the previous encounters and I'm very happy to be on this one. And I thought that I'd pick up from where you left off last time when Tony Taubman suggested that the TRIPS agreement will facilitate initiatives to combat COVID-19. These are often international collaborations and they involve international transactions. And so I take his point that TRIPS creates a level playing field and has an enabling function in these kinds of transactions. However, international IP law also entitles right holders and empowers them in ways that can conflict with efficient R&D, research and development, and with the diffusion of the results of R&D. So TRIPS entitles right holders because it requires WTO member states to give creators exclusive rights over technological advances and also certain types of technological data. As important, it allows members to increase the level of protection through free trade agreements, and many free trade agreements do exactly that. So the level of protection goes up. What TRIPS doesn't do is gives those who wish to use protected materials, such as patented pharmaceuticals, any rights at all. That's left to the states. TRIPS and FTAs include exceptions, but the state's room to maneuver is quite limited. And indeed, the one WTO case about the flexibility to promote patient access to medicine, that provision was read quite narrowly by a WTO panel. Now, Tony Taubman also spoke about the WTO's Doha Ministerial Declaration, which, as he mentioned, emphasized the rights of WTO members to deal with health emergencies, and which he also said stressed that the TRIPS agreement is to be interpreted in light of its object and purpose, which includes protecting health. And since that session, just in the last week, the status of the Doha Declaration was addressed by this recently handed down WTO appellate panel decision in the Australia plain packaging case. Now, while the AB declined to opine on the legal status of the Doha Declaration, it did confirm its interpretive role in deciding on the breadth of TRIPS obligations and also exceptions, and Henning will come back to that later. But that does leave a lot to the states. Some may be more willing to limit IP holders' entitlements, and some less. I'm from the United States, which has been very patentee friendly, so it's at the lesser end. Furthermore, as I said, international law also empowers right holders. By that I mean first that TRIPS and FTAs allow states to challenge another country's use of flexibilities. Of course, that requires right holders to convince their governments to do that, and maybe in this climate, public relations considerations may prevail, and states may be less than totally willing to challenge another state's attempt to take care of the health of their citizens. But second, many states are subject to investment agreements, and these give right holders themselves the ability to challenge any action that diminishes the value of their investments. And so the results are that there are two sets of problems. First, how can states consistent with TRIPS, with these free trade agreements, FTAs, and investment agreements, IAs, make sure that researchers can use materials that are the subject of IP protection in their research? So these materials would include genetic sequences of the vaccine itself and the things it affects, existing patented drugs. So we already have remdesivir and dexamethasone have already proved to be useful in treating COVID-19. So we want to look at other drugs, medical equipment. So for example, ventilators could be optimized to deal with these particular problems, but they're often patented. And also patented advances in bioinformatics. So bioinformatics is important to analyze what's going on, to track infections, and we're also searching for bioinformatics and other methodologies for tracing contacts. So that's one question, doing the research that's needed to develop all these new tools. The other is about the treatments, diagnostics, and vaccines that are actually developed. These are all patentable subject matter. So once discovered, there's also a question of how states can, consistent with TRIPS, FTAs, and investment agreements, ensure that everyone has access to them. So hand it over to Henning.
Yes, thank you. Okay, so I'm just going to add briefly to what Rochelle has said in order to outline my main points here, I suppose. And first of all, let me thank Laurent, Javier, Manolo for making this possible and for inviting me. So my main point is really somewhat picking up on what Rochelle said about how the international intellectual property system essentially coordinates and globalizes protection, but leaves the access side primarily to states to address, right? And that's a point I want to flag up and I want to discuss a little bit further. So what I mean by that is if you start, for example, with one of the provisions Rochelle also already referred to, Article 7 of the TRIPS agreement, that is the provision which is meant to set out the objectives of the agreement. That's the title of this provision. And that mentions essentially utilitarian motivation for the protection of an intellectual property and sees that in two ways. Number one, to provide incentives to innovate, of course, but in the same way, also IP rights are there to promote the dissemination and transfer of technology, and that's being picked up as a particular point in Article 7 as one of the key elements which are protected by IP rights. So it doesn't mention copyrighted works or trademark protected signs, but technology, I think, here is the key sort of representative of the generally IP protected subject matter. So if TRIPS is in its objectives essentially both about promoting incentives but also promoting access, then the whole system is, in its more specific rules, perhaps as we have them at the moment, primarily focusing on, in fact, promoting incentives by means of intellectual property protection, and not at least globally coordinating the mechanisms for promoting access. So what I mean by globally promoting the mechanisms is that if you look at it, the question of access is, as Rochelle was already pointing out, primarily a question of domestic law and a question of how states effectively, for example, make use of exceptions. Exceptions in the agreements, in principle, are optional. They're not mandatory. They're not, in that sense, harmonized, because if you look at the main mechanism used for that purpose, the so-called three-step test, it's harmonizing only to the extent that it sets out general parameters under which national exceptions can exist, but it doesn't specifically harmonize what kinds of exceptions that should be, which is probably a good thing because we need some degree of policy space as well. But there's not even an attempt to somehow ensure that there is a globalized mechanism for access. So compulsory licensing, again, is something which is primarily optional, and in principle, if you look at the TRIPS rules, is territorial, operating in a particular domestic market. Now, there are some mechanisms, I'm just going to point to one or two of them, and one I'm going to discuss later on in more detail, which do, in fact, in international IP law, serve to some extent to coordinate access. So if you think about the more recent Marrakesh Treaty from 2013, this is essentially about cross-border trade in copyright-protected works in accessible format for blind or visually impaired persons. So it's essentially coordinating mechanisms of access to IP-protected goods, in this case, copyrighted works, in these accessible formats. You could also think about the more recent, it's in a regional rather than global context, Digital Single Market Directive of the European Community, European Union, that is, which has mandatory exceptions for certain types of user-generated content if they are being used on platforms where, under Article 17, Section 7 of that particular directive, certain exceptions for parody, for news reporting and otherwise must be available to users, even if, for example, a platform like YouTube otherwise is instructed to block content, right? So again, you can see some degree of coordinated access across the EU in this case. Last mechanism, which is primarily important for our context of access to medicines, which, however, I think is not really a mechanism at the moment functioning to promote global access, is the Article 31 bis mechanism in the TRIPS agreement. So this is about issuing a compulsory license in one country in order to export to another country which doesn't have sufficient manufacturing capacity. But it's essentially a bilateral mechanism. One country issues, the other country receives. There's some further caveats to it, and there's some opportunities to broaden it, but that's something maybe to answer in a later question. So my main point here is to say, especially in a COVID context, right, where there's this, well, in the New York Times, for example, there was an article recently saying that no community is eventually safe until all of us are safe. An outbreak anywhere is a risk everywhere. So from that perspective, if in particular in the COVID context, there's a basic utilitarian argument for global access. Of course, there's also, in addition to that, a humanitarian argument. And as a last point here, maybe to say or to flag up as an introductory matter, in free trade agreements, as a matter of trade policy then, if we, and that's brought out in one of the references we've shared in advance in the materials, if we are essentially dependent on generics from countries like China or India, we might want to think about whether it's really a good thing to significantly ask for stronger protections for patent rights in these jurisdictions primarily also it's going to affect access or has some implications for access abroad in all these countries where generics from China, for example, might be disseminated into. So that's my sort of broader point, this point about globalizing access and mechanisms for that purpose. Thank you.
Thank you very much. Thank you very much, Henning and Rochelle, for these brilliant replies. And you have actually facilitated my work tremendously as moderator, since we received in our Q&A many questions related to the issues you have already clarified. I now have a second question. Haven't patent right holders pledged their patents and data to the common good? At the previous encounter, the WTO TRIPS director mentioned the access to COVID-19 tools Act, such as the accelerator system, which is basically the packet. Also, there is COVID-19 guidelines and recommendations of the Research Data Alliance. So as such, do you think that these rights, these patent rights on COVID-19 medicines are already pledged in the format of patents and common good?
So to some extent, I think that that's true. We put some of the things that were mentioned last time into the materials for this time. So you can see the link to the COVID-19 guidelines and recommendations, for example. But they are mostly about data, about how to format that data so that researchers can use it, and also rules on use. It was created by a group, the European Commission, the United States National Science Foundation, and National Institute of Standards and Technology, and the Australian Government of Innovation. So that agreement mostly covers data generated by governments and those who fund the Access to COVID-19 Tools Act Accelerator. That's an agreement to share health technologies, so that's closer to what we're really interested in. And it was signed by various philanthropic organizations that are funding some of the research, like the Bill and Melinda Gates Foundation, by various nonprofit, non-government organizations like Gavi, the Global Vaccine Alliance, which brings private and public entities together to develop vaccines. It was also signed by organizations of generic drug manufacturers, the World Health Organization, the WHO, and IFPMA, which is an international lobbying arm of the pharmaceutical industry. However, there hasn't been very much buy-in by individual originator pharmaceutical firms. As some of the articles linked in the materials note, some of these firms have labeled the idea of making vaccines and treatments available nonsense. They say this is expensive and risky research, and the funding of it is heavily dependent on earning a profit. So one question is whether these organizations can be moved to take a more public regarding stance. And another, of course, is what happens if they refuse to do that.
Right. Henning, you want to complete the reply?
Exactly. Maybe just to add, perhaps again more on the question about the international frameworks which we might have in this context, and I'm going to focus more broadly on frameworks for technology transfer, and they can work in both ways, right? And now I'm not particularly focusing on intellectual property rules, but more broadly looking at mechanisms within the international domain where states have agreed in hard law or more soft law instruments to facilitate technology transfer. And that can be by means of so-called push or pull arrangements, right? And I'm going to say a little bit more about one or two of those. So a pull arrangement would be one which essentially requires the transfer of technology, and a push arrangement would be one where you have an incentive to the private sector to agree to technology transfer. For a pull arrangement, clearly IP law has something to say in terms of compulsory licensing, for example. For push arrangements, you could say, of course, that the existence of patent rights in themselves create incentives not only to engage in research, but later on maybe also to license the outcoming results. But leaving the IP systems aside, you have a whole range of, for example, international environmental agreements, the UNFCCC, the UNCCD, so this is a convention on the combating of desertification, and they have technology transfer mechanisms, and they've tried rather to incentivize technology transfers, but they haven't, to the extent I'm familiar with them, not been particularly successful with that. And you have a mechanism, another mechanism, which is probably closer to what we are talking about here at the moment, which is the World Health Organization's Pandemic Influenza Preparedness Framework. So this is a framework which, as the name suggests, it's about pandemics and influenza preparedness, which had been developed in response to, I think it was the H5N1 crisis around about 15 years ago, 2005, 2007. And at some point, Indonesia, where a particular strain of that virus was found, broke existing practice and refused to share the genetic makeup of a particular virus because it wanted guarantees that it would receive sufficient amounts of vaccines in exchange for that. Now, in a way, in order to respond to these demands, the World Health Organization set up this mechanism. It's a soft law mechanism. It's focused on influenza viruses, where there had been lots of virus sharing since the late 1940s, and where there was a pre-established sort of cooperation amongst relevant institutions. So it doesn't apply to COVID, because COVID, as far as I know, is not an influenza virus. But even if it would apply, one would see that perhaps some of the flaws in that mechanism is that it doesn't really, I mean, once the state has shared the virus, like in this case, China did, I think, quite early on, or one can debate about how early on, but China eventually did share the genetic makeup of the coronavirus. The quid pro quo inherent in this mechanism to say, okay, you're going to get vaccines in exchange, might not be that too interesting for China in this particular case, because China probably can easily produce most of the relevant drugs for themselves, because most of the manufacturing actually happens in China. And for other countries, there may not be a quid pro quo here. And even if there is some form of a quid pro quo, the rules are soft law. The technology transfer rules in that particular mechanism are not really binding the right parties who hold the technology, because if anything, it's an agreement between states. And that is, I think, a key flaw in these mechanisms, that we are not really getting to the right parties. And so you're kind of left with these voluntary mechanisms, which, as Rochelle mentioned, one probably needs to wait and see whether these voluntary mechanisms hold. So that would be what I say on this particular point. Thank you.
Thank you very much, Henning, and Rochelle, for both comments on this point. And precisely, what can be done to facilitate innovation in face of IP rights on fundamental research inputs? Can WIPO play a role? Can the WTO play a role? Can the WHO play a role? Should soft law, should the issue be left to national law or to soft law? What can be done in this respect?
So on the whole, the structure is that international law allows states to do things, but the rights are actually owned by individuals. And so the first step is that states take a role in making sure that the right holders actually do things that encourage research and access. So, I mean, what could be this? So at the national level, what done? First of all, by the government, and governments could attach strings to their own financing. So they could require inventors to make output available to follow on researchers, and to some extent, governments do that. The National Institutes of Health certainly encourage it, if not require it. They can also prevent what seems to be going on here, which is called molecule flipping. So molecule flipping actually means something to chemists, but this is a different kind of molecule flipping. Here, the idea is that people are selling, or I should say government labs that are funded by the government are selling promising candidates of treatments to middlemen who are then selling them to other researchers and who are selling them to firms for the purpose of making drugs. And these middlemen have been increasing the prices quite high. So one thing the government could do is prevent those kinds of sales to middlemen. The other thing, and there's a paper in the packet written by one of my students on this, is that in a lot of cases, some of this research is not only funded by the government, but it's actually partly done by researchers that work for the government. So for example, in the laboratories of the National Institutes of Health. And the government could be asserting their own rights to inventions and then being part owner of the patent and being able to license it out on their own terms themselves. So this is something that I know the US government is starting to get interested in as a result of a lot of activists convincing them they ought to be interested. For research that's sponsored by others, the government can rely on research exceptions, on crown use for countries that have a crown, and government use for countries that don't, like the United States. Some states already have such exceptions, but whether they're broad enough to cover this issue is a real question, since most of these exceptions are not used or not allowed to be used if there's any commercial possibilities in the future. And of course, here there are certainly commercial possibilities in the future, maybe not while the pandemic is on, but in years to come. And so one lesson of the COVID-19 situation might be that these exceptions need to be much broader than they are right now in the case of national emergency. In the United States, there's a sort of kink in the United States Constitution as it relates to patent law, and that kink allows states to do research with patented inventions, and they are not subject to litigation for damages. So some research could be conducted in the United States by state universities. But again, it's important to note that patents are there to incentivize investments, and so getting the right balance is hard. And of course, we also have to make sure that anything that states do, other than conditioning their own funding, things like new research exemptions or expanding research exemptions, all of that raises this question of whether it's compatible with the TRIPS agreement, with FTAs, and with investment protection.
Yeah, and just maybe to pick up on that particular point Rochelle just ended up on. So we have, of course, in the WTO TRIPS agreement, which is in that sense the main multilateral treaty setting out substantive rules on patent protection. The one rule which deals with exceptions, I mentioned it before, Article 30 of the TRIPS agreement, which, as Rochelle had mentioned, was subject to an interpretation which was rather sort of, well, on the narrow end of things. It could have been more narrow, I suppose, because if you look at the way the copyright version of that three-step test had been interpreted, I think slightly later than the Canada patents case, that was even more narrow. But nevertheless, I think if you had a country trying to broaden its domestic research exemption and allow for activities which some point in the future down the line might have a commercial implication, I think especially a reading of TRIPS Article 30, which is based on Article 7 and 8, and that may be something we can discuss later on in terms of the role of the Doha Declaration to promote that, because Doha, for example, says in paragraph 4 that all WTO members do agree that nothing in TRIPS should be interpreted or implemented in a way that prevents access to medicines. So if research exemptions promote access to medicines in the long run as well, without unduly impeding the incentives, then an interpretation of TRIPS would be one which would facilitate or would allow these kinds of exceptions in national laws to exist. So I think on the TRIPS side, I think we could at least, on the basis of the language in the treaty, plus taking into account the Canada patents case, which, by the way, was decided prior to the Doha Declaration. Of course, Article 7 and 8 existed at the time, but the panel probably, had the Doha Declaration at the time, would have given some more thought to these provisions. Now, TRIPS is one thing, FTAs is another thing. In FTAs, we probably don't see too many times particular restrictions on exceptions to patent rights, at least from my review, or I wouldn't say it's a systemic review, but from looking at these issues in FTAs, I can't recall a particular one where the three-step test would have been more narrowed in an FTA to allow for less. However, an area where this probably might play a role is investment treaties, and where investors relying on intellectual property rights, in this case patents, as their investment protected under the treaty, could try to argue that a too broad interpretation, especially if it's one which sort of all of a sudden appears, of a national research exception, is something which is contrary to arguments of legal stability, arguments perhaps even made of expropriation and so on. We'll look at the investment side of things in a moment. So just to flag that as a potential issue at this point as well. Thank you.
Thank you very much, Rochelle and Henning. And precisely, from theory to practice, we should turn to access. You have already introduced the issue of access. Are you worried about whether there will be enough vaccine to go all around very rapidly, and about high prices? So in addition, it appears that at least some governments try to, when they give funding, try to accompany it with a kind of vaccine nationalism, in order that the countries that finance manage to capture research efforts so that their citizens be served first. So what can be done? What can be done in this field so that international law be properly respected, and so that all citizens may be equally of the planet may be equally served? I would give the floor first to Rochelle on this. This is something which is crucial. From research to access. Research is a key issue. Of course, we should incentivize medicines, including through patents, but access is a citizen's right. So, Rochelle, the floor is yours.
Well, you asked before about what institutions can do, and of course the WHO has been trying to influence development here and trying to influence access and also research. They are a bit hemmed in. Their rules of operation are the international health regulations, and these protect state sovereignty to a very large extent, which makes it a little bit hard for them to deal. But they've been doing things like shipping medicines. They've been coordinating first country clinical trials. They're providing databases. They are trying their best to get equitable access, and they're launching pooling arrangements. But a lot of this has to do with what international is really going to be left to the states, as we keep saying, and they have to operate within the international rule system. So I'm going to turn it over to Henning to talk about the international system, and then I'll come back and talk a little bit about what states in particular are trying to do within that framework.
Yeah, thanks. So on the international system state, let me maybe just begin because I 2 days ago attended a Zoom conference organized by Queen Mary, and that had, amongst other things, lots of excellent contributions. But Peter Drahos had an interesting case study he presented, and he started out by saying in this context that, I mean, the current talk about a people's vaccine can be quite cheap. It depends on whether that rhetoric will actually be followed on once we have a vaccine, and when question arises about who gets stockpiles of the drug with what type of priority. So the case study Peter discussed, just to reference it here briefly, is one where the H5N1 virus, the bird flu virus, was eventually tackled, I think, by a drug called Tamiflu. which was seen at the time as the most effective essential treatment for that. And the countries who had more economic might were very easily able to obtain large stockpiles of that particular drug, whereas poorer countries seem to have not really received much, only later to find out in a particular review by a professor at Harvard that this particular drug, Tamiflu, wasn't that effective after all. So that's just probably one anecdotal story which might lead us to question as to whether we can actually rely on this rhetoric of people's vaccine to be materialized in a way that poorer countries will receive equal amounts of that kind of vaccine. And clearly it's understandable to some extent if countries want to take care of their own people, but in a globalized world, I think we also need to account for the situation, especially with the COVID virus, that we're not really safe until everyone is safe. And in addition, that countries which otherwise have a strong healthcare system, where perhaps the immunity or the degree of immunization in the population is better, or perhaps the ability to cope with the virus is better because the overall healthcare system is stronger, might therefore see it as a humanitarian responsibility to give some degree of preference to countries which don't have these features. So looking at that, you have, for example, a recent WHO Assembly resolution. So this was the assembly which had taken place about, I think, 2 weeks ago now, which strongly urged for universal, and I'm quoting, timely, equitable access and fair distribution of all quality, safe, efficient, and affordable essential health technologies, then specifically going on to say that that needs to be consistent with the provision of international treaties, including TRIPS, and referencing the flexibilities of the Doha Declaration. By the way, the US did not, to my knowledge, participate in that particular meeting, nor did it agree to this resolution. And later on, from at least what was said at that meeting, Zoom meeting at QM, had turned around and criticized this particular resolution. So the resolution doesn't, of course, create anything new, but it essentially references TRIPS and the Doha Declaration. And here I just want to focus briefly on what I said at the introduction about the mechanism we have so far in order to coordinate access, right? And this is a mechanism which is trying to address IP barriers. If the barriers are not within the IP context, but if the barriers are simply solely on manufacturing capacity, that mechanism alone is not going to do very much, right? So that's the caveat we need to start with. But this mechanism, which was established in the post-HIV crisis at the turn of the century, so in the Doha Declaration in 2001, which we mentioned many times already, the paragraph 6 of that declaration calls upon WTO members to establish a mechanism to allow a country which has insufficient manufacturing capacity to be able to ask another country to introduce a compulsory license for a particular drug, which of course in that other country needs to be under patent, otherwise it would be able to produce that drug anyways, but so to issue a compulsory license for export. And that is because another provision in TRIPS otherwise would not allow to solely produce under a compulsory license for export. So this new mechanism under Article 31 bis of the TRIPS agreement is, however, essentially a two-country model, right? One country can ask and another country then can supply if it wants to. It doesn't really allow for sort of broader scale distribution. It has one further caveat in the sense that it does allow for dissemination of these kinds of drugs to all members of a regional trade agreement if the majority of the members of that agreement are least developed countries. Now that's good for least developed countries, but I think that kind of approach could be taken a little bit further. And that could be one mechanism if you look proactively and don't worry about the political economy of actually getting this done and changed in the WTO. That could be probably changed in a way which allows this mechanism to facilitate access more. There's some further issues with that mechanisms, but I'll leave it at that for the moment. And there's a range of other flexibilities within TRIPS, issuing compulsory licenses per se domestically, allowing parallel importations and so on and so forth. not, for example, protecting a new use of a known product, things like remdesivir, where you have it being patented initially for, I think, treatment of Ebola, and now it's found out to be useful for treatment of COVID as well. So these kind of things could serve as further flexibilities. I'm going to hand over to Rochelle and maybe discuss some of the operation of those on the domestic level, and later we can perhaps go back to discussing the investment treaty questions which arise if countries proactively use these flexibilities. Thank you.
Thank you, Rochelle.
Yes. In the materials, there is a link to a document that tells you all of the things that countries are doing, or actually provisions that are in national laws that would help both the access for researchers and access for patients. This is the WIPO policy tracker. But countries are also moving ahead on various things to do specifically for this situation. So just to give 3 examples, Canada just passed some emergency legislation allowing the Minister of Health to authorize the making and using of patented inventions to the extent that it's necessary to respond to a public health emergency that's a matter of national concern. France just granted extraordinary powers to the French Prime Minister, enabling him to, among other things, impose compulsory licenses where they're necessary. In March, Israel actually granted a compulsory license to allow the importation of various generic versions of a list of drugs that look like they are potential candidates for consideration. So countries are moving ahead with this, but again, the question is TRIPS consistency, and I think as Henning just pointed out, these things probably are consistent with the TRIPS agreement. They're probably consistent with free trade agreements because the free trade agreements generally don't have any specific provisions on this, although some might. But they do undermine investors' expectations for what they're going to be able to get out of the things that they invested in. And so investment agreements are one of the things that I think is most concerning about this entire situation, especially the new provisions that that countries are enacting after there've already been investments made in some of these candidates for treatments as diagnostics and as vaccines. So Henning, do you want to say something about that?
Yeah, I mean, just to continue on that point, and Rochelle and I have both been working in this whole area of how intellectual property rights apply in this broader context of international investment law, as lots of others have done in more recent times. Now, this is an area where I think already since the first so-called modern BIT, or the first BIT of the kind which we are looking at when we're talking about investment protection, in 1959 was signed between Germany and Pakistan. It already included a clause saying that the investments would include patents, technical know-how, and other types of intellectual property rights, if I believe. So IP has been considered as a protected investment in a range of, or if not most, investment treaties. We also have, and that I think is a good thing, an increasing, a better understanding now. I would say it's not really many cases yet we have decided on this, but we're getting a better understanding in the sense that holding an IP right per se probably isn't sufficient to properly trigger investment protection, but that the investor has to engage more significantly in the host state in order to actually enjoy this protection. And that may curtail some sort of situations where you simply have obtained a trademark, a patent, or a copyright and want to invoke these protections against the host state, because often the outcome of that would be somewhat, well, I think, problematic in light of how the specific rules of the IP system has been set out. So, but if we assume for a moment that a protected patent is in fact a protected investment, then investors or IP owners who can qualify as investors under an investment treaty would, for example, be able to argue that individual measures which significantly affect the economic exploitation of their rights constitute an expropriation. That would be one line of potential arguments, and most of these treaties contain provisions which limit expropriation. And the key issue here is that you usually owe full market compensation of the investment at the time before the relevant measure, be it a compulsory license or otherwise, had been introduced. And that compares very favorable with the type of compensation or remuneration you would owe under the TRIPS agreement, where it's about adequate remuneration. It doesn't say full compensation of the market value of the investment, and it's not normally understood in that way. So here, that's an easy case to appreciate how the investment treaties effectively override some of the flexibilities Rochelle and I mentioned earlier. The probably even more problematic scenario is where you rely on the sort of catch-all type of protection under investment treaties, which is the fair and equitable treatment standard, which has over time been developed to mean lots of things in investment treaty arbitration, including a degree of protection against states changing their laws. So it's some degree of expectation of legal stability which is being protected, protection against protection of legitimate expectations against those expectations being frustrated. And there had been a case where Eli Lilly, the pharmaceutical company from the United States, sued Canada over its particular approach to patent utility, or it was probably not only a question of usefulness or industrial application of the patent, it was a so-called promise doctrine. I'm not going to discuss the details here at the moment, but the outcome of that case can be understood to suggest that a dramatic change in the domestic law could be potentially problematic from a perspective of the fair and equitable treatment standard. It could also be read as rather a question of judicial economy, and that the panel in that case only decided that since there wasn't a dramatic change, all the claims were going to be rejected anyways. But it is a somewhat open question. And if you apply this to the current scenario, you already have large law firms, at least, pointing out the possibility for investment treaty cases to be brought by those who are affected by COVID-related measures. So it is, I think, a not completely unrealistic scenario that some investors with sufficiently deep pockets might take this up. And the problem is not probably so much that this will happen many, many times, but the fact that states might shy away from taking measures which they otherwise might want to do because they're afraid of being sued and losing huge amounts of money in the process. Thank you.
Thank you very much, Henning, and Rochelle for both replies to these important questions. Indeed, we consider that in the current days, altogether 37 countries have opted out of the normal functioning of the IP system, or are opting out for it. Certainly the issue of FTAs, as raised by questions from participants, and their ineffectiveness in this respect, or the dangers they may represent sometimes, are affecting the IP world. I just have a personal question before coming to participants' questions. And I would appreciate much your brief reply on this, since we have not much time left. So we are talking of reconstructing intellectual property. Are the problems relating to research and access to medicines linked to the IP system in general, or to its specific instances of protections? I mean, the way in which IP is applied in practice. A systemic problem or an applied problem?
Okay, for me, just very briefly, I think as the discussion so far has shown, IP is one but a significant factor of many factors, which both has an impact on the incentives as well as the access. So whether in practice on the ground it is really the principal or primary issue, that I guess depends, and I'm going to pass over to Rochelle on that.
Rochelle?
Well, I mean, I do think that the FTAs are a systemic problem, that there's been this effort to raise protection without thinking about the fact that the entire world actually needs things. And maybe the COVID-19 situation will actually teach countries that continuing to raise protection is just a terrifically terrible problem. On the level of national laws, I think because of the fact that investors could bring these cases, countries have to start anticipating what might happen in national emergencies a little more than they have, and perhaps broader research exceptions, I think, are one thing that we learned here. Another might be about the scope of patentable subject matter. So the world laughed when the United States decided that genetic sequences were not patentable subject matter, but maybe they were right, that we need to make sure that these sequences are available to all researchers, especially in cases of a pandemic. There's been this move to protect genetic resources, to allow countries to own the genetic resources that are found within their territories. And I think maybe this shows that that also needs to be rethought, and we need some exceptions there so that the world has access to the things that they need to know in order to find the things that we need.
Thank you very much, Rochelle, and Henning for these replies. I really much share Rochelle's views on the systemic dangers that FTA may represent to international trade law. Though unavoidable, they represent a major danger. And also, I really share your comments on the issues connected with the patentable subject matter, in particular connected to fundamental research. I would now wish to really move to the questions from our audience, and in particular, there are many, and I would wish to raise mostly those that have not been directly or indirectly replied to. So many governments are using apps to track and contain the spread of the virus by collecting, processing, and sharing personal data. This has raised many concerns. Some concerns are not at all of intellectual property. They are due to risk of privacy breach, but there are also connected to unlawful uses of collected data that may relate to intellectual property. So what should be done in that regard? As we have, I would wish to try to bring many questions. So I would really much appreciate Henning or Rochelle very brief headlines of replies, and then possibly through our chat and through further discussions, and also through what we post on our website, we would continue the dialogue.
Right. I mean, so on the question you just posed, I'm not sure what kind of specific IP issue would be raised other than personal data or privacy or data protection issues. So if governments use various technical tools in order to collect data of individuals, I guess you could think about personality rights in a way, and maybe that may be the IP angle. But I think the main issue here is privacy and data protection, and the questions about whether the public health concerns and social distancing enforcement is, for example, overriding then private rights or rights to privacy. That would be my main question here. Rochelle, do you have any additions to that?
No, not really. I mean, I do think that this increase in privacy litigation, in privacy protection rather, is another example of this notion that every bit of information somebody gets to own. And so maybe you own your personal data, maybe you own, a new use of a known pharmaceutical, but this notion that everything is subject to ownership is something that I think is really being challenged by this whole COVID-19 situation. So to the extent this is a privacy problem, I think it raises many of the same questions of, do we really think that people should own everything, or is there a public interest in being able to share information, at least for particular purposes?
Thank you very much for your replies to both. I really share this approach on the dangers of private appropriation of everything and nothing at the end. So this is a major danger for not only for social rights, but also for economic rights of society. Another question from the public, which is very general, but still should be raised today. Is artificial intelligence trustworthy enough to assist in the response to the current pandemics?
Okay, so for me, briefly again, I would say artificial intelligence in itself doesn't really exist. It's always the entity behind using it, or the programmers programming it in a particular way, and that it being exposed to training sets of data, which allows us to make some determinations on how that AI functions. And there, I think we have ample examples of not trusting it too much. So I'd be rather skeptical, especially in employing too many electronic tools without having tested them sufficiently, because these are in a way a product which or service which can create significant implications for individuals. So I'm always more on the skeptical side here.
Thank you very much. Rochelle, you want to add something, or it's fine? Okay. So thank you very much for these really synthetic replies. I would wish to raise from the public again another technical question on the patent assertion entities. In the US, patent assertion entities have asserted patents against some companies that were developing some tests to tackle the outbreak of the pandemic. Do a patent work as genuine intellectual property rights, or do they represent a burden, a monopoly that really restricts access to knowledge and inventive activities? So what fails in the system, and what can be done to improve it?
Yeah, so when I mentioned that one of the things that the government can do is try to control who gets access to patents over government-funded inventions, that was one of the things that I was thinking about. Universities, I think initially, universities are the main recipients of government funds and the main place where a lot of this research is being done. And I think at the beginning, universities were very naive about who they were turning over patent rights to. And I think that's caused some of the problems. Some of these patents are still owned by these middlemen who are either selling them, flipping them, or suing on them. But the bigger problem of patent trolls also has a lot to do with the way that inventions in the IT sector are claimed. These patents have always been extremely broad, and so it's been very easy to make arguments that the patent covers all kinds of new things, such as new kinds of tracking and contact tracking information. So a lot of these patents are probably not valid. And the United States has done two things. One is to make it a little bit harder for patent trolls to bring these lawsuits. And second, the United States has created new and much cheaper ways to challenge the validity of these patents. So a lot of these patents are going to wind up, I think, being declared invalid, or at least not applicable, either through litigation or through challenges back in the patent office. But patent trolling has been a significant problem, and I'm sad to hear that it's occurring in this situation too.
Thank you very much, Rochelle, for these comments. I would wish just to raise one last question, which relates again to FTAs that have been criticized. is there a risk with the diminution or the temporary diminution of the role of the WTO that we find through arbitration institutions a lot of opportunistic litigation that hampers at the end the development of medicines or the access for all applied in the field of medicines? And this brings us also to the topic of our next encounter, which is international arbitration.
Yeah, that I think is a very good sort of a question to end on in light of your future topic. So I think we have to distinguish between two things. So we have the IP chapters in these FTAs, which are primarily, in my view, problematic because of their very in-depth and comprehensive provisions, which often are exporting a particular domestic law of the country which has been pushing for these agreements, say the United States or the European Union or other players, and asking the recipient country, the trading partner, to implement these very precise provisions in their domestic law. I don't think so much that these provisions are going to be subject to much adjudication. They're primarily going to be subject to diplomatic pressure. If you look at the China-US P1 agreement, the one agreement between US and China, which has been concluded in January. So that doesn't really have an adjudication mechanism attached to it. Eventually, what this agreement will lead to, if one party alleges that the other party doesn't comply, is the tit-for-tat trade war coming back. So in FTAs, sometimes you do have dispute settlement proceedings, provisions for that, but I don't think the IP chapters have been at all been subject to any challenges I wouldn't know of. CAFTA has some FTA dispute settlements, but they're related to other things, not IP rights. So I don't think dispute settlement is going to be the main issue on the IP chapter, but of course it's going to be a main issue on investment. And that's what we have discussed before, where next to the bilateral investment treaties, which have the self-standing reference to investor-state arbitration, also the investment chapters in FTAs do exactly the same thing. So that, yes, is particularly problematic because it's not the state bringing the dispute, it's the private party. And the private party in that context has nothing really to lose because it never can be subject to the other end of the proceedings. It's always going to be the complaining party, and it has a systemic interest to push for the broadest possible interpretation of the protections available to it. Whereas in the WTO, of course, states will be subject to disputes and will be disputants. So I think that is truly a problematic point, yes.
Yeah, I've looked at a few of the investment agreements that have been entered into. I've looked at all of the ones entered into in the last year, and it's very interesting to see that almost every one of them has increased the amount of protection that states have when they are trying to advance interests in public health. They've either taken public health activities out of investment protection entirely or limited it in very, very severe ways. And so I think that this is another thing. States have learned this partly from the Lilly case and the other the Uruguay case, the other investment cases that we've had, but they are certainly also learning it from this COVID-19 situation. So the COVID-19 situation has taught us an awful lot about the way that IP works, and I think maybe it's a silver lining for having had to endure it.
Very, very good. I think these are extremely important comments. Before closing, I would just wish to raise one question. Should there be a form of grace period in the in IP protection that should apply in the context of pandemia? This is a question that raises from the public. In particular on disclosures, so that we encourage disclosures at this very time without hampering possible other rights. This is a more practical question than a technical one. It has been raised by the public, and I think it may have its importance. So before closing down, I would really ask your comment on this.
So the question is whether there should be a grace period within international law or national law. So a great
the question hasn't been raised in this sense, but
Yeah.
I would suggest that we precisely bring it in this very case to international law. Should there be a grace period? Would TIPSA allow it? I don't really see how, but could something be done so that we admit forms of recovering novelty for inventions that have been disclosed in this very moment?
Oh, yes. So that's happened during wars. During World War I and World War II, obviously the Germans did not apply for patents in the United States and vice versa. And part of the treaty to settle those wars was to allow applications to go forward, even though things had been invented before. So that's possible, but it would have to be something that countries either agree to, either in bilateral agreements or multilateral agreements, or through the international system, but it's not in TRIPS right now, so it would have to be added. And maybe that's another thing that will happen after this, is that we'll look at the TRIPS agreement hard and decide what needs to be changed in it.
Maybe just to add from my side, I mean, just picking up on Rochelle's earlier point that we're probably too much thinking always about adding more and more rights. And maybe this is a situation where we, rather than thinking about how to preserve incentives by means of later rights, more rights, or whatever, we think of alternative mechanisms and think of ways other than the specific IP system to promote incentives. And so maybe that's something where at least equal thought should be given to. Thank you.
Thank you very much. I really thank you very much for your time, for what you teach us today, and also for the replies to the various questions from the public. Indeed, we pretty well perceive that the question connected is not only an IP question, but is a far more general one. Yes, there are ways to review some loopholes or absences of harmonization in IP law, as you have both pointed out and as Rochelle has now expressed. Yes, the FTAs may represent some dangers, though they may be unavoidable, bearing in mind the difficulty in creating in advancing in international IP law with 200 sovereign countries. So indeed, these are questions that we bring with us at the end of today's Global Digital Encounter. I warmly thank the speakers, Henning Grosser-Rüsekan and Rochelle Dreyfus, for their authoritative teachings today. And also, I wish to really thank the public for having raised so brilliant questions and for being so numerous with us today. At this very stage, I propose to formally close the Global Encounters. I would wish, today's Global Encounter, I would wish to thank colleagues, Professor Manuel de Santos, Fide colleagues, and all the colleagues all around the world who have supported us and brought us to permitting fascinating debates. I would also wish to thank all the staff that who supports us, some 20 people, and I am really glad that we will continue with very soon a very attractive topic, which is IP arbitration in digital environments. Thanks to everybody, and see all of you very soon on the 22nd of July. Thanks to participants from all over the world. For the questions that couldn't be replied to live, we will provide replies through the Q&A. Thank you very much, and see all of you very soon.
Thank you.
Thank you.
Thank you. See you.
See you very soon.
Bye.